Imagine the moisture content.
Yes.
Actually, a trigger point. Yeah, if you're ready to
Eyes in favor?
Yes, we're sorry to have kept you waiting. We'll make up the time if we need to.
My Lord, I have 2 hours on the agreed timetable to deal with quite a lot, and the order in which I propose to deal with it is by making a few preliminary remarks, then to deal with the overall structure of the appeal and the case and what we say the issues are and how they should be approached, before moving on to deal with grounds 1 and 5, and because 2 and 4 overlap with my learned friend submissions, I might make a few observations if there's time, but I will otherwise be happy to rely upon our skeleton argument.
Very good.
So, this is the appeal of Mace, pursuant to permission of Lord Justice Males. There is no cross appeal and no respondent's notice. And the reason that is significant is because, perhaps not surprisingly, consistent with Insurer's position in that regard, they only appeal the definition of damage and the decision on retained liability in the Sky action, not in the Mace action. There is no appeal on that. There are separate actions. They may have been heard together. Now, that may lead to some unusual consequences, and it's right, therefore, that I point it out straight away. In particular, one can visualise a situation where insurers may be successful in their retained liability as against Sky, and Sky would then, pursuant to the terms of the construction contract, seek to recover any shortfall from Mace. Mace would then rely on the indemnity under the policy and the declaration in its action, both as to be indemnified up to practical completion and in respect of being one retained liability, and it would join in insurers in those proceedings to enforce that indemnity. Now, it's not for Mace to understand how and why we're here in that situation, save to say we pointed out that degree of absurdity from the outset. The consequence is, so far as Mace is concerned, that it's very keen not to see anything which might undermine the judgment so far as Mace is concerned, because that would be perhaps through a collateral means to increase its liability or potential liability in circumstances where it would have had no opportunity to address those issues before this court.
Are you asking for that opportunity?
I'm not asking for that opportunity. I am saying this, that were there an appeal, we would have put in a respondent's notice and we would have argued it on different grounds. And to be clear, some of those different grounds, if one went to our submissions in the trial, we made many of the same grounds, but we made some submissions on different grounds, in particularly on a different basis with respect to retained liability.
Well, that might form a reason for you having identified, I think before now, that you were an interested party who wanted to be heard on the point. As a matter of, it seems to me, in any subsequent dispute in which the point becomes relevant, you won't be bound as a matter of res judicata, but you will be bound as a matter of precedent by a decision of this court. This court will regularly allow non-parties to be heard if it's satisfied that it's appropriate to do so in order to protect its interest on a point which might affect it. But the point will be dealt with by Mr. Edwards, and if you wished to advance different grounds, it seems to me that you ought to have previously identified those and sought to intervene on the insurer's appeal against Sky in order to advance them. That's simply how it strikes me at the moment.
Well, I'd like to hear that, but if I may say this, this is not something that's raised for the first time. An insurer's position on this was it was all irrelevant so far as they're concerned. I just want to make
it is irrelevant so far as they're concerned. It's only you who've identified a problem for you.
Yes, well, I
have to say that at the moment I'm not terribly sympathetic. If you weren't advancing any or wanting to rely on any new matters, then you would no doubt be happy for the points to be argued on your behalf by Mr. Edwards. I say no doubt. Perhaps you would. But if you wanted to rely on additional grounds, it seems to me that you ought to have identified that.
You can only rely on additional grounds if one is seized of it.
No. Non-parties are often given an opportunity to take part in proceedings to which they are not party if they have a legitimate interest in a point that is going to be argued.
My Lord, I understand that. I was simply finished because I've got a lot to get through.
Yes.
With this observation, we drew this to the court's attention on permission by writing to the court. We have made our position entirely clear. Yes. And the response we've had at all times is it's irrelevant to our action.
Yes.
I'll leave that matter, my Lord, because obviously I've got a lot, and I hear what your Lordship says.
And as it seems to me, it is irrelevant to the appeal which the insurers have chosen to mount.
My Lord, in which case, perhaps I then move on to another, in a sense, preliminary matter.
Yes.
Which is the participation both in...
I should perhaps make clear that what I've just said represent only my thoughts, not those of the tribunal.
No, and
only my provisional thoughts without wanting to deflect you by hearing a lot of argument.
And I'm sure my Lordship can understand it was important I draw that to your attention right at the outset.
I don't want it in some subsequent hearing them to be taken as firm views of myself, let alone firm views of the court.
No, that was certainly not how it was understood. Good. It was merely a discussion with counsel.
Yes, let's move on.
Yes. So, participation in these proceedings and in this appeal. One of the points taken against us by insurers is that Mace doesn't have a real interest in this appeal because it didn't have a monetary judgment in its favour. We would simply make this observation that in relation to ground 5 in particular, that can't be right because, as I'll come on to explain, ground 5 was a claim for incurred costs of Mace, and those were only sums claimed by Mace, and there was no claim by Sky, and for the reasons I'll explain, there couldn't have been a claim by Sky. The third point relates to the utility of declaratory relief. And plainly, so we say Mace has an interest in that declaratory relief for broadly the same reasons that I've explained in relation to the first point, but also because one can visualise at least the potential for an attempt at a subrogated recovery. The fourth point that's made is that Mace has no independent right to payment in respect of any monetary judgment. And that's a point that was referred to in the judgment. And we would simply perhaps point out the obvious, that under all risks policy of insurance of this type, they are treated as one policy, but in fact, they're really a whole series of policies, one for each one of the assureds, and that's how it's treated as the legal fiction. The effect of that is that one goes to the terms of the policy to decide whether somebody is entitled to a monetary judgment or not, and no other document. The right to payment was agreed as between Sky and Mace in the construction contract. And so there is a distinction between the rights under the policy and the rights under the construction contract.
Yes. You say the fact that you both have a right to payment and the insurers are not liable to pay you both doesn't undermine each independent right to payment.
One can understand why that might be important in relation to other matters, which is why one goes for a money judgment and declaratory relief. And the final sort of preliminary observation is as to the characterisation of Mace's remedial scheme. Mace's remedial scheme is not one that put right and was intended to put right damage as at 2021, but for the reasons I intend to explain, was fulfilling the indemnity as at the end of the period of insurance. But to do that required a number of things, one of which was, of course, so we say, an extensive investigation of the roof. And that is an important, expensive element of the remedial scheme. And those principles were well understood, not least because they were understood through the vehicle of the pleadings. And I don't intend to take your lordships to it, but to give a reference in relation to Sky, in relation to their submissions at Supplemental A, tab 5H, page 42, paragraph 263(1). It was in Mace's amended reply, core B, tab 24, page 740. So it was well understood, or should have been well understood, what our position was. Turning to the grounds of appeal.
Can I just ask you this? Speaking for myself, I haven't looked in any detail at the Mace scheme. If your appeal were to succeed, are you suggesting that we could jump straight to saying the judge should have applied the Mace scheme, or would it have to go back to the judge in the same way as I think Mr. Edwards accepted that if he's successful, it would have to go back to the judge?
We say the Mace scheme is the applicable scheme for the reasons we've explained.
That's
so
not an
you
answer to
wouldn't.
My question.
Well,
are you suggesting that we can find that
yes,
on the evidence that we have? And if so, can we do that without looking in detail at the Mace scheme?
I think that would overstretch myself to push it that far. And so you can find the principle.
Yes.
But the reality is it's...
The practical consequences of what we find in principle would have to be resolved by the judge.
Indeed they would.
Oh, thank you.
So ground one addresses loss and damage and the judge's failure to make any or sufficient findings, we say, on Mace's pleaded and evidence case. Of course, Sky's case addressed damage at the end of period of insurance, and they've dealt with, if I may use the term neutrally, continuing damage. We accept some of the principles as they have advocated to the extent they apply to Mace. And those would be, for instance, its submissions on law on continuing damage, issues such as mitigation would also fall into that category. Ground two covers much the same territory as Sky, dealing with plenums, upslope damage surrounding the lifting strops, and the mineral wall insulation. Grounds 3 and 4 deal with the judge's failure for rejecting the Mace scheme. And that can be broadly broken down into 2 points, which is because of the judge's failure to deal with the issues in ground 2, i.e. plenums, lifting, strops, insulation, he effectively then misdirected himself as to what was the correct remedial scheme. And if your lordships were to remit this back to the judge, it would have to, and were in favour of our ground 2, one would have to remit it back for findings on those bases and how they would affect the remedial scheme. Our ground 4 really is the mitigation argument in relation to the remedial scheme. And I'm going to come back and explain that in a little more detail. And ground 5 is the incurred costs of about £10 million, which was dismissed. Mr. Windfuss for Sky explained or introduced the principles that apply in respect of what is essentially a factual appeal. And we would simply adopt them by saying that the test for us is it plainly wrong? Does the reasoning contain identifiable flaws? Are there material inconsistencies and clear gaps in logic? So with those preliminary comments, I am going to start by, if I can, explaining the principles as we see them, how they apply to the Mace appeal, but they may well apply to the Sky appeal as well. And we start by identifying 2 points. The first is, so we say the judge failed to understand the nature and extent of the indemnity provided by the property damage or risk policy of insurance, and as to the effect of insurer's breach. And the second is to say that the judge appears to have failed to deal with important issues, and to the extent he dealt with some issues, he either didn't understand what was correctly an issue, or there are errors of logic in relation to his conclusions. The result of that, so we say, is he didn't give effect to the remedy to which Mace was entitled as an assured under the policy. And we start, I think, in the same place as my lords started one discussion, at least, with Mr. Edwards, which is to identify the nature of this insurance policy as being a hold harmless policy, and you're being held harmless from the occurrence of physical damage. In this case, the Sky Central, from inception of the policy through, in Mace's case, to at least practical completion.
Yes.
We say
This is the Fanti point.
Yes. Well, it is and it isn't. And if I...
How does it differ
Well,
from the way it's being put by Mr. Edwards?
I think it differs substantially. And this arose really because I was listening to the discussion.
Do develop your submissions.
Yes.
But have that in mind.
I do. But it seems to me it's equally a question of whether it is part of the indemnity. So what we're really looking at is not necessarily mitigation, but what is the indemnity? And so there's no mystery about it. What I'm going to submit to you is that actually when you look at breach of a policy of this type, one that you're held harmless, the question is, at the relevant date, and in Sky's cases at the end of the period of insurance, and at Mace's case, it will be practical completion. What is required to restore them to that position so they are held harmless? And the mistake, so we say that when one looks at it broadly, is that people are putting schemes into place that can't be affected at that date. So it's either a 3-year or a 5-year scheme where there's continuing damage. Where I think Mr. Edwards is right, I don't know whether he put it this way, is to say, if you choose as an insurer to go down the route of saying the right way to do it is to take a longer period, so it's not put right at the date of the relevant date, and further damage occurs, the indemnity includes the remedying of that further damage. Because the alternative is to say what scheme could be, and we use the phrase at trial, wished into place at the date, the relevant date, being the end of either the period of insurance or practical completion. And the only scheme that could achieve that would in fact be the new roof, Sky's case. And the reason that is so is it's the only scheme that doesn't require lengthy investigation to find out the scope and extent of the damage and where it's located within the roof. So the actual entitlement of an assured under this policy has to be ascertained at the relevant date, which is the end of period insurance or practical completion. And the scheme advocated by insurers seeks to have its cake and eat it. Because what it says is, the right scheme is take 3 years and it will remedy this damage, and that is the damage at the period of insurance, but it will take 3 years. Meanwhile, further damage is occurring for which we are not responsible as insurers, but you, the assured, is responsible and will pick up the cost for. And that, we say, is not right as a point of principle. What's right as a point of principle is if one is determining the indemnity, the remedial scheme to fulfil the indemnity at the end of the date of insurance, then one has to have a scheme to give effect to that. So one can take a simple example of a building that has a structural defect. Immediately end of the period of insurance, the remedy may be very significant to replace that. Or over time, repairs can be devised to be dealt with. But if in the interim the building falls down, what the insurer says is, that's the responsibility of the assured. We only have to remedy the damage at the end of the period of insurance. In other words, if there is a point of principle here...
So when you say the building falls down, are you saying the building falls down because of the defect,
yes,
or because of some...
No, because I'm taking...
You're excluding some novus actus.
Yeah, because I'm taking it out of sequence, I quite accept that if there is a different peril that causes it to fall down...
Causation is the...
Indeed, that simply doesn't apply. But what's being advocated for insurers is not a full indemnity at all. Because what it says is there is this scheme that we put forward to remedy it will take 3 years, but the risk of additional damage during that time is with the assured. That is not holding it harmless. To look at it another way round, if you are held harmless, that subsequent damage wouldn't happen in this case. And this is not, I want to be clear, so we say, any case of a continuing peril.
But the difficulty with this way of putting it, which is different from the Fanti point, is that you're treating the indemnity as if it were a contractual promise to pay an amount which indemnified you. Whereas the Fanti tells us, and I think this is pretty uncontroversial given the history of the law, the promise is to indemnify you in the sense of preventing you from suffering the insured damage in the first place. That's what the indemnity is.
Yes.
It's an abuse of language to talk about a promise to indemnify you in the sense of a promise to pay you money, which holds you harmless.
Yes.
The Fanti point is, as I understand it, the indemnity, the promise of indemnity is to stop you suffering the insured loss damage by the end of the policy period, then it becomes an unliquidated claim for damages. The measure of damage is governed by normal principles of contractual damage, causation, remoteness, mitigation. And that may involve a claim for damages, which involves paying for the cost of damage which occurs after the period of insurance, because that is simply a cost which arises under the normal rules of damages, causation, remoteness, and mitigation. That, as I understand it, is Mr. Edwards' first ground, and I understand entirely how he puts that as grounded in principle.
Yes.
Your argument seems to be, no, there's a promise to pay an amount which indemnifies, and if that is the argument, I'm not sure how that arises.
No. It's not the argument. I have said there's a promise to pay, but in my mind's eye, that's not my submission.
But I'm still struggling to see how your argument differs from Mr. Edwards' first ground.
It's not a mitigation argument. It's not to say that you take some positive act or some positive step during the course which would be an otherwise increased damage and you can recover.
No, that's your ground four, and that was only lightly touched on by Mr. Edwards and certainly wasn't his first ground.
Yes. The submission I'm making is to ask what is the effect of this particular indemnity when an insurer can choose a scheme by which you are held harmless, but which has the effect of causing further harm or further damage. And we say that's not the true nature of the indemnity.
Well,
the true nature of
the scheme doesn't cause further damage.
No.
It's just the working out of the scheme allows further damage to flow from or follow from the original insured event.
And
I think.
my lord, that's right. But the question I suppose I'm seeking to address is which scheme or what scheme has the effect of holding the insured harmless at the relevant date, the period of insurance. My lord says you look at the insured damage, but one's left with the artifice that one doesn't know the extent or state of the insured damage for some considerable period of time. If one is actually standing, so I would submit, at the correct point and asking herself at the correct time, which is at the period of insurance, the only scheme that would achieve that would be a new roof, because there is the unknown location of the damage. So an insurer can't say that I can put forward a scheme that could only have been created sometime later and say that is the scheme. It's true it is repairs the indemnified damage, but if events have occurred between the two.
Well, I'm not quite sure where this argument takes you. If your argument is that your scheme is the correct one because investigation is not something that was required, then why haven't you failed to mitigate by not repairing the roof immediately any damage was discovered?
Our submission is that the correct scheme was.
If you say investigation is simply not necessary.
No. I'm saying effectively there is a choice for an insurer, a notional choice, which is to say, if one wants not to go through the process which takes time of investigation to get to a remedial scheme, the only solution which achieves that is a new roof.
Yes.
If, however, one wants to go down the course of investigating, find out precisely where the damage is, and so forth, during that period of time, further damage occurs. But that's part of the remedial scheme, the race rule scheme, to remedy that, because that would then be the correct scheme.
But I had understood, maybe I misunderstood you, but I had understood you introduced these submissions by saying the reason that the Mace scheme which involves completely replacing the roof, is the right one, is that one doesn't have to investigate exactly where the damage is. I'd misunderstood.
That's the Sky scheme, I said. If I said Mace, I meant Sky, but I thought I'd said Sky. Because the Sky scheme is a new roof. The Mace scheme is repairing all damage after a long investigation. That's the difference between the two schemes. Insurers is a scheme that says, we have a long investigation, but we only repair the damage that existed at the date, the relevant
and we
date.
don't pay you for anything that has developed in the meantime.
I'd misheard you, I'm sorry.
One thing that slightly troubles me in the way you've been putting it is it doesn't seem to me that the insurers have any role in choosing or imposing a scheme at all. And what we're talking about is there's damage which has been suffered at the end of the period of insurance, and what we're looking at is what is the insurer's liability to pay for the repair or replacement.
Yes.
And we're just looking at the schemes are not, as it were, an obligation of the insurer or a right of the insurer. They're just simply what represents the right assessment of the cost of repairing the damage as at the POR.
Yeah, my lord, that's correct. But to get to that assessment, one has to look at the content of a scheme. And I could pose the rhetorical question, which is, a scheme could take 1 year, 5 years, 10 years, or 15 years. And by that I mean insurer's scheme, as opposed to a shorter period, say, for the one put forward by Mace. During that time, the damage...
I'm sorry to hold you up, but I'm still having... You say that the Mace scheme involves investigation for the time necessary, putting in place remedial measures, and then replacing that which is found to require replacing after that process.
Yes.
And I thought that what is said against you is that isn't what the Mace scheme says. It says replace every single one.
Yes, and that's why one of my preliminary points is why I gave you reference to the pleadings, to say that isn't the Mace scheme. It could be the Mace scheme if every single set is found to have an amount of damage.
I see.
And that's why, in a sense, trying to shortcut it, I gave my lord reference to Sky's closing submissions, which address this, and to Schedule 1 to Mace's amended reply, which pleaded it. So it says, for the avoidance of doubt, Mace's amended reply says, the avoidance of doubt, the Mace scheme seeks to remedy damage which was sustained during the period of insurance, not simply damage present at December 2021, so not all the damage. And what Sky said was, the Mace scheme entails the opening up for comprehensive investigation of the roof and repairing or replacing deteriorated timber, OSB and wetted insulation. The nature and extent of the works will depend to an extent on what is found in the opening up works. The works likely include the replacement of the entire upper layer of OSB and Derbigum and repairs to further elements as required to reinstate.
So does it follow that you weren't seeking a fixed money sum?
Well, we were, because we were saying...
How could you if you didn't know what works were yet going to be needed?
My lord, I understand that, and that's why we had an alternative plea in the particulars of claim that said, and if the court finds something different, or indeed after the opening up, if further damage is found, then we would come back pursuant to a declaration for further payment. So we did consider that possibility. So if I may briefly just develop my submissions,
Yes.
so that, in a sense, taking them out of order sometimes can lack clarity. The first thing is, of course, factual context. Inception of the policy and its date of breach. And at inception of the policy, what the parties knew was that this was the construction of the largest flat roof complex building, in the sense that it was occupied by creative people. It wasn't just simply a warehouse in Europe. And it was reasonably foreseeable at that stage, if there was damage to the roof, it was likely going to be substantial and may require substantial works. At the date of breach, which convenience says that it's treated as the last day of the policy because of its nature, so the breach may, of course, be earlier dates where damage occurred, is on a construction project when it's likely to be handed over to the owner or occupier. And the hold harmless principle requires them to be held harmless as at the relevant date, in respect of the indemnified damage. And so where I agree with my Lord Popplewell in it, saying that therefore one looks at what is to restore the insured damage, and where my submission departs is to say what one doesn't do is lose sight of that on the remedial scheme. If a result of putting forward a scheme perhaps a more economic or even a more practical scheme allows further damage to occur, one starts with the principle about what is required at the date of the indemnity.
You talk about the last day of the policy, but it is for your case where your insurable interest ceases at practical completion. Are we concerned with damage at the date of practical completion?
My Lord, yes, I am.
In terms of the insured loss?
But not because of the reason that my Lord has just said about insurable interest, although the judge made a finding on that, and that's not an appeal. There is, in the bundle, the case of Feasy, which wasn't referred to by the judge, but was the last Court of Appeal decision on that, which takes a rather different view about whether possession is required for an insurable interest. But because it's not necessary for this appeal, I thought it might arise, and we put it in there more to highlight the point, to tread with care when one looks at that part of the judgment. Because right. We accept it's practical.
But leave aside insurable interest.
Yes.
In terms of Mace's claim under the policy,
yes,
the obligation is to hold you harmless from insured loss, that is to say, loss occurring prior to practical completion.
Yes.
Can we proceed on that basis?
We can.
Thank you.
It's common ground that the judge found, and the judge found anyway, that there was significant water ingress into the roof during construction. And that's in his judgment, but it's also Corby 15A414 is the page reference. Damage at practical completion was put in issue. I raise that because the judge said it wasn't. And I'm going to give my Lord the references as to where it's in issue. It was the amended defence that raised it in August of 2022. As we made the point in our skeleton argument before that, it was a common position that both Mace and Sky were insured up to the end of the period of insurance. And the amended reply at paragraph 53L, which if I can take you to just to show you, because...
So damage at practical completion was put in issue because in the amended defence you put in issue what damage had occurred prior to the end of the period of insurance.
No, that's why I'm going to take my Lord to it. No, I didn't say that.
I'm sorry, I must have misheard you.
No, what I said was damage as at practical completion was put in issue in the amended defence,
yes.
First of all.
Yes.
Hitherto, the position was that it was common ground that both Mace and Sky were insured up until the end of the period of insurance. Mace responded to that in its amended reply, and if I can take you to that in Core B 15A at 414. Sorry. Is it 707? Sorry, I've got the wrong reference. It's 707. At 53L.
So did you say 717?
At 707.
707.
And picking it up at the end of the second line, Mace claimed to an indemnity in respect of damage occurring before or on the date of practical completion remains unaffected. Mace notes that the defendants had no pleaded case as to damage which existed at practical completion. The reason Mace put it that way is because Mace's position is there is no difference between the damage at PC and the damage as at the end of the period of insurance, and I shall explain why that is so. The judge found that at practical completion there was no remaining design defect. As a temporary roof was no longer required, the roof being sealed. And so, in our submission, this is not a case where it can be a continuing peril case. Because, oddly enough, the defect, one of those rare cases, no longer existed. He found what there was, however, was continuing or spreading of the damage that existed at practical completion, because the water had entered the cassettes and through the mechanisms explained by Mr. Edwards, propagated. And it continued to do so. So the key feature as at practical completion was water trapped in an unventilated roof and remaining in situ, resulting in further damage until the end of the drying out works in 2019. Now, the indemnity under this policy was to pay the full cost of remedying the damage, i.e. in the basis of settlement clause. And to pay the full cost, there are two possibilities, as I've explained. The first is not to participate in investigations, but to put in place a scheme which will remedy that damage, although it may be more expensive than strictly necessary. And that would be how I would categorise the sky roof. The alternative is to take the time to investigate, to find out the precise nature of the damage, the location of it, and put in a remedial scheme that is to be designed, then approved by Sky and implemented in an occupied building. And to do that, there is a consequence for that alternative approach, which is that there further damage is occurring. But as a decision, as part of the remedial scheme, that was a sensible and pragmatic approach to take. But our point is that in respect of the remedial scheme, that is part of it. As much part of it as a scheme that requires the top deck to be opened up and to be investigated. And the judge seems to have accepted the principle that at least an investigation is required and a design produced for a remedial scheme. And I've given my lords the hypothetical example, I say, of a building which can be remedied at the end of period of cover, but that will cost more money because the scheme doesn't have investigation to fine-tune what remedial works need to take place. Or alternatively, one can fine-tune it and do it at a later date, but that may include any subsequent damage as part of the scheme.
Can you just, for me, can you just put into a legal framework the decision you're talking about? I mean, I just have in my mind's eye this sort of idea that at practical completion, let's say everybody's just tootling around the building, admiring it, and then somebody says, ooh, cassette one seems a bit squidgy.
Yeah.
There's water. How's that got in there? To which Sky say, right, we want a new roof. The whole thing. Insurers say, come off it. It's just a bit, it's just a cassette one. And you may say, look, let's be reasonable about this. We should go around opening up sequentially the cassettes to see whether this is more widespread and how much actually needs to be done to remedy. We don't necessarily need a new roof. That's the reasonable thing to do. And if it takes us a bit of time to get round and some of the cassettes have deteriorated in the meantime, well, that's down to you insurers. I mean, that's the sort of mental picture I have. But it's not a legal analysis. This decision you're talking about which course to follow of those rather caricatured courses I suggested, what's the legal framework for that? I mean, how do you fit it into either the contractual framework or mitigation or damages? What's the legal sort of framework about that decision?
Well, we say that's just a question of construction of the policy, the basis of settlement clause, which talks about the full cost.
But who makes the decision? The decision you're talking about is a decision made, as it were, on the ground.
What?
At practical completion in the little vision that I had in my head, which is the point in time at which you said, in a sense, the contract would require something to be done. But legally, whose decision is it? Is there a decision to be made? And if so, where does it come from?
It's all of this, because of the nature of the project, is in a sense hypothetical, as the judge found when he produced proxy schemes. Because he said, well, they're not going to be built, so these are proxy. And he took the date for the proxy scheme.
But it's a proxy for what legal principle?
For the indemnity, for what is the full cost. Whether you know of the damage or not doesn't actually prevent you being indemnified for it. So knowledge of the extent of the damage is not the test.
So it's for the insured to say, this is what we're claiming, based upon our schemes. Is that the way it works?
But this is an issue that, in a sense, is an issue, but is a wider problem. Or one can take the same issue as a limitation and say the damage occurs, although the insured may not know it, but time runs. The question is, at the date when the damage is to be tested, what was it? And then one goes on to ask, under the indemnity, which is the indemnity for the full cost, what is reasonably required? And then you have I understand, so that's the legal question, but it's the practical working through of it, which is actually what perhaps this...
It is the legal, so you say the legal question is, what can an insured reasonably require by way of being made whole
Yes.
by the insurer?
What is reasonably required to be made whole? It's not what one particular party requires, it's what is sensibly required to be made whole. The point about my submission goes one step further.
And who bears the burden of showing that it's either reasonable or unreasonable?
Well, in the usual way, an insured must make its claim, and it must prove its claim for the insurer to pay out. So the burden obviously rests on an insured to achieve that.
To come up with a reasonable scheme, is that right?
Yes.
A reasonable basis upon which to determine the compensation which the insurer has to pay.
Correct. And then, as here is, the insurer comes back and says, well, we don't agree with that. This is the scheme we think. But looking at that scheme...
Yeah, but I don't want to get into...
I understand.
I'm trying to sort of put it into a legal framework.
Yes.
I understand practically why this would happen, why there'd be a bit of toing and froing and debate about how best to do it in the practical world. But in the legal world, it's for the claimant insured to say, we've suffered loss and damage.
Yes.
This is what's required to fulfil the settlement clause.
Yes.
We put this forward as a reasonable basis for determination of our loss, which you, the insurer, have to pay.
Yes. That's
But at
correct.
the end of the day, as in any damages claim, the ultimate arbiter is the court.
I understand that, but it was working through
Yes.
the policy coverage point, and the court determines whether they were right or wrong about that.
Yes, but all that one's looking at is an assessment of damage. Is it not?
My lord, yes, but it doesn't answer the question, because looking at what the damage is calculated by reference to a scheme to put it right. An insurance scheme ignores the fact that it takes time and things get worse. But Sky scheme, in fact, doesn't do that. It says it's a new roof.
Yeah.
And in a nutshell, that's it.
Well, if insurers are not liable for ongoing or increasing damage, however you want, then, because one of the problems about that is it takes mitigation out of the analysis. And normally in an assessment of what is the right amount to pay based upon what is the cost of remedial or works, one would take into account that there's an obligation to take reasonable steps to mitigate. And of course, what part of your analysis here, it seems to me, is quite straightforward. If there isn't a liability for the ongoing or increasing damage, because there's an obligation to mitigate.
So my first submission is...
Factored in.
My lord, I'm sorry for interrupting. My first submission is, yes, it's part of the indemnity. If I'm wrong, it's not part of the indemnity, then there's a duty to mitigate. So it's not, I don't die on the stake of saying it's part of the indemnity. It's my first submission because the opposite is, it's simply saying you can't divide the practical reality of what is required from the nature of the indemnity itself in cases of this sort.
Well, and as I understand it, going back to a comment you made earlier about having insurers trying to have their cake and eat it, I think that's what you said.
I did. It was perhaps too colloquial.
No, I think I got it. I'm quite happy to go with it. I mean, what you say is if Sky immediately upon, in my little hypothetical, immediately upon discovery of a soft spot on cassette 1, Sky says, right, we want a new roof, all 484 cassettes have to be replaced, that's it. The insurers would be entitled to say, wait a minute, that means that we would be required to pay for the replacement of a lot of things which have not, in fact, suffered physical loss or damage within the meaning of the policy, because you don't know.
Well-
you say the way in which you make the policy work is that you actually have to look cassette by cassette to see whether in fact they have suffered the insured loss and damage. But insurers can't have their cake and eat it and say that they're not prepared to pay for any continuing damage caused in the intervening period of investigation.
In a nutshell, that's it. Yes.
So I understand that. So that's my understanding of your observation, that you say in the same way that Sky wouldn't be entitled to say contractually we're entitled to a new roof because they can't prove that there's. That doesn't mean you can prove that there's loss in the cassette. Neither could the insurers say, well, we are not obliged to pay for any deterioration if in fact the reasonable requirement of the insured is to say, well, okay, so let's open it up and see cassette by cassette whether there's loss and damage.
Yes. In a sense, there are obvious subtleties to that there may be sufficient evidence to infer there's damage to the whole roof, but if you can't, then of course that principle can't be taken too far, because if the rest of the roof, for instance, is to be found to be defective or have no problem at all, and all it was there was one soft spot, then the insurer wouldn't pay for the investigation just to find out there was no problem, unless that was a reasonable course to take.
Yeah, I mean, if cassette one shows a soft spot and you open up 100 more cassettes and nothing is found, then at some point you'll say, okay, wait a minute, we don't need to open up the other 300. It's looking like that was a one-off, but that, you say, is just part and parcel of working out how this contract is expected to work in the context of a big roof like this, which, although everybody talks about it as if it's a roof, in fact it isn't a roof. It's an assembly of 484 individually hermetically sealed cassettes, as I understand.
Yes.
Yeah. Okay. So that's how you say this contract is intended to work, which is a contractual framework.
Yes, I do. Yeah. But that's why I talked about factual matrix, in a sense, both at the time of inception and the time of breach, because that raises the question, how do you fulfill the indemnity? What is the content of it in this particular case?
And you say the parties couldn't have intended that somebody who didn't just say, I want a new roof, would be placed into the position of conducting what you say is a reasonable investigation, but without being made whole for taking that course. Yeah.
My lord, yes. I don't want to labour the point, but it seemed to me it's important in this context, because you can see, for instance, in ordinary residential properties, how there might be a problem with the roof, and there might require some investigation that needs to be done. There might be some further damage if it's been damaged, and so forth. And it's an important question as to what, in those circumstances, when one has to do further investigation, who pays for that, and what happens in the interim, and who is responsible, be it by way of mitigation or because it's part of the indemnity.
And when you say that's a matter of the construction of the basis of settlement clause, is your submission that that's because what is meant by full cost of repair is not full cost of repairing insured damage, as defined, but full cost of all repairs that are made necessary by the suffering of insured damage, including any subsequent damage which occurs during what might be described as a reasonable mitigation period?
My lord, yes.
Is that as a matter of construction what you say is meant by full cost of repair? Because I think what's put against you is full cost of repair means repair what? Answer, insured damage.
Indeed.
Full stop.
I understand that, but then they say, yes, and it's going to take us 3 years to work out what the scheme is, and the risk rests with the assured during that 3 years, not with us.
Yes. So your construction of the basis of settlement clause is that it means full cost of repairing what?
the full cost of repairing, in a sense, to be precise, it's the full cost of repairing the indemnified damage. But in order to do that,
You need to investigate.
indeed,
And if the investigation results in non-indemnified damage, by which I understand you to mean the damage as defined in the insuring clause,
that's part of the investigation and of the remedial solution.
I'm not sure that gets you within the basis of settlement clause. You can either say, as I think you did in your latest formulation, that full cost of repair is limited to the full cost of repairing insured damage, that's to
Yes.
say that which occurs prior to end of period of insurance stroke practical completion, which is insurer's case. Or you can say, as a matter of construction, which I understand is the juridical basis on which you put this argument, that it's the cost of repairing the damage which is suffered as a result of the insured damage during any period of investigation.
In a sense, I don't want to fence on this, but I'm placing an emphasis perhaps on what the meaning of full cost is.
You are, because, I mean, let's take a slightly different point. Suppose you know that there is damage which is being caused by some insured peril. You need to find out where it is,
Yes,
because you don't know. If the fact you look in 100 places and spend time and employ somebody to do it, to look in 100 places where there is no damage before you find where in the 101st place that's where it is, you say, well, the entire exercise is the full cost of repairing the damage.
yes,
Because you had to find it.
yes.
And you say insurers couldn't turn around and say, well, we're only paying for that 101th time of the person who was looking.
Yes.
Because that's the only point at which they actually found the insured damage. In order to find it, they had to look at all the other places. And you say, well, that is part of the full cost of
It is.
repairing, because you had to find it.
Yes,
That's your point.
it is my point.
That's fine if the investigations find damage which had occurred prior to the end of the period of insurance and was insured damage. I quite understand that in a sense that's an ascertainment case, but we're concerned with a slightly different problem, which is that during the investigation period there is deterioration stroke developed damage, which is different damage. And I quite understand that if you say full cost of repairing insured damage covers the cost of investigating and finding insured damage, that is to say that which has occurred as you subsequently ascertain it prior to the end of the period of insurance or practical completion. But that doesn't get you home on the problem in this case, which is why I had understood you to be having to make a slightly broader submission on what is meant by full cost of repair, is that it's not just the cost of repairing insured damage, even if it takes you 2 years to find it. It's the cost of repairing further damage, which it's reasonable to have only discovered, which has occurred subsequently over that period of 2 years or whatever it may be.
I think I was making a perhaps third point, which is why I said there was a choice about how the indemnity is satisfied. By saying the insurer could say, I don't know where the damage is, or we agree we don't know where the damage is, but we agree it's got to be remedied. And the only way to remedy that at the relevant date is by having a new roof over it. And that's what I meant by choice. So there's that.
Yes, but forgive me, I'm sorry.
I do understand.
I wanted to pin down what your submission is on what is meant by full cost of repair. Repairing what? And your answer to me was it's the full cost of repairing the insured damage.
Yes.
Now, if it is so limited, how does that cover the cost of repairing uninsured damage? That is to say, damage which occurs after the period of insurance. Just looking at your construction point.
Yes, but I'm placing emphasis on the word full cost and giving those words content. and to repair the insured damage requires the investigation. It also means that there's going to be some further damage that occurs as part of that, both, to use my learned friend's phrase, of intentional damage or access damage and unintentional.
If I made my example slightly better and said, rather than just as we're hunting around, in order to find where the damage, or to assess the insured damage, the actual damage sustained during the period of insurance, you had to drill some holes. And then obviously you'd need to cover them up. Well, obviously that damage wouldn't have been caused during the period of insurance, but you'd have to make them good. You'd say that would be part of the full cost of both finding and repairing the insured damage. So
if there was a leak in a pipe behind one of these walls, you would have to go through the wall to repair the leak.
And you'd say it's no different, as it were, drilling the hole, which you'd then have to seal up, is no different, you say, I think, in concept from having a program of finding and repairing, during which time, in the ordinary course of events, some further damage would have occurred as a result of the original insured damage.
My lord, yes, and on going back again briefly to factual matrix, I'm reminded the size of this roof is 16,000 square metres, and therefore it must have been appreciated, so we say, by somebody who was experienced in underwriting this sort of project, that finding damage was likely to take time and to have consequences. And that should be the give the meaning to full cost. But perhaps I can come back to this, but perhaps I can make one or two further remarks on it. The first is that this is not a case where no mitigating action was taken. There were three drying out processes that took place in total, the first two of which were unsuccessful. It was only the third drying out process that was successful, and that was by August 2019. So works were taken which were not wholly successful. We would draw attention to certain costs which were permitted by the judge, such as decanting staff and so forth, which occurred after the period of indemnity, but are a necessary consequence of giving effect to the remedial scheme. And in my submission, that's no difference in quality and principle between compensating, in effect, for the additional damage required to do it and the movement of staff after the event to permit the remedial works to do it. They are of a similar type. Dealing with chronology, it's clear that when the judge if the judge considered the position as a practical completion for the purpose of the pleaded case of Mace, he would have been forced to conclude that the water in the unventilated roof at practical completion was damaged. And the reason that was because it was sealed in then, and exactly the same state of affairs existed as at the end of the period of insurance. It was no party's case that any of the remedial works could have been completed prior to the period of insurance.
I'm sorry, that's my fault. I didn't quite.
It was no party's...
The proposition immediately before that. If one had looked at the position at practical completion.
One would have been forced to conclude, because he found water in the cassettes was damage,
Yes.
that there was damage in existence at practical completion.
Yes. Thank you.
So it's going to be my submission that Mace pleaded damage at practical completion. The judge, by deduction from his judgment, found there was damage at practical completion, and Mace was entitled to a money judgment which gave effect to that. The chronology shows that first, remedial works could not have been completed prior to August 2016, and that's the judgment at paragraph 210. Second, that it was not until 2019 that the damage ceased because of the 2018-19 works. But he found there was no additional costs of the remedial works required from those required at the 15th of July 2017. Those drying out works took a cumulative period of 14 months. Had the judge realised it was an issue, and had he realised he had found damage, at the very least he would have considered that drying out works would have been required of the same extent and of the same type that actually took place after the end of the period of insurance. Applying that time period, assuming one's applying logic, one gets to about June 2017. During that period, as we know by looking at the period...
It's my fault. You say one gets to June.
It's what I'm
June
taking a period...
2017 as a date at which what?
Was 14 months being the period of the drying out works that actually took place, known as the 18-19 scheme.
I see. 14 months from practical completion to June 2017.
Trying to apply by parity of reasoning precisely the same facts. Until they were completed, there would be continuing damage. Damage in the sense of the water having effect on three categories of material. One is the orientated strand board. The water affected the glue in it, and a phrase used at trial was it became like Weetabix. The second one was the insulation.
Can I just be clear what you're actually saying as a matter of practicality here? Is it because you can't simultaneously dry out all the cassettes?
Yes.
Or is it that even if in a cassette that you start drying out on practical completion plus day one,
that is
even during the drying out process of that particular cassette, there will be continuing damage?
Perhaps I can break it down into the elements. In relation to the insulation, the evidence was, so we would say uncontested evidence, that the insulation is immediately damaged by water, the ingress of water. That is because it loses its thermal properties, because it slumps or compresses. Drying out doesn't affect that. The presence of water throughout the period was itself damage, category 2. the orientated Stramble, there was evidence in the judgment that by about August of 2016, there was evidence of soft spots and decay. And finally, there is the wood. And that was the material that took the longest to dry out and upon which Mr. Coulson gave evidence. In respect of three of those items, which is the OSB, the insulation, and the water remaining in the cassette and spreading, they were all damage which, whatever happened, must have been present at practical completion. And I should add, if remedial works were undertaken, it was still propagated until those works were completed.
So I'm just not sure. I'm not sure I've just understood what you said. At practical completion, there was, let's just take an individual cassette.
Yes.
At practical completion, there's water in it. Yeah. So that's, you say that's damage in and of itself.
Yes.
The presence of water causes the insulation to become sodden and it slumps.
Yes.
Compresses. And you say that the drying out wouldn't remedy that.
Yes.
So that's damage of itself at practical completion.
Yes.
I'm not sure why you say that at practical completion, on the assumption there's just water in the cassette, there would be damage to the OSB or the wood.
Well, I'd put the wood into a different category deliberately. Right. On the OSB, the judge found that in respect of the piece of OSB that was found to be very substantially damaged in August of 2016, that would have taken a period of between 12 and 18 months, I think, to get to that position.
So practical completion is?
It's 4th of April 2016.
Right. So at least some of the OSB may have been in a damaged state.
Indeed.
At practical completion, but some might not be.
Indeed. But the judge decided it wasn't a pleaded issue. There was evidence from which he could draw a conclusion. I quite accept my Lordship's analysis in relation to the OSB, that he would have to draw a conclusion or an inference whether some or all of it was damaged at practical completion. But he never, it seems to us, addressed his mind to that.
It's my fault, and I'm sorry to hold you up because I know you're short of time. But we are now on ground one. I think before that,
well,
we've been covering a much broader point that the judge was wrong to say what he was concerned with was the damage at practical completion. But your ground one,
yes, is damage at piece.
Assume he was right on that.
Yes,
he should have given you a monetary claim in relation to that damage. And as I understand the way you're framing the argument is that there was some damage at that stage.
Yes.
It would have required drying out.
Yes.
It would have required drying out for 14 months because that's what it took later. If it had taken 14 months, that would have taken you through to June 2017, which is, as near as damn it, the end of the period of insurance. The judge found that there was no difference in the cost as at that date compared with 2018, 2019.
Yes.
So, do you say, at the least, Mace should have got what Sky were granted, namely the insurer's 2018-19 scheme cost?
Indeed.
Is that what the argument is?
That is the argument,
Right, thank you.
albeit...
Right. Sorry, it took me a while to work that out.
No, and I do understand that.
That's, of course, without prejudice to your argument that that's the wrong starting point.
Yes. What I'm trying to do here is summarise in the time available to me what the arguments are, and they lose something, I'm afraid, in the telling one doesn't ground them in the facts.
And the argument as I've articulated it,
is correct.
Was that ever articulated to the judge?
No, my lord, but there's a reason for that. That we didn't know what the findings...
No, the reason was because you said that's the wrong starting point.
Yes, but the judge made a finding of what damage was, and it was not until we saw the judgment, we saw the working through of that, and that there was an error of logic in not continuing, and we didn't know that at the time.
Yes, and you pointed out that you had a pleaded case, that at least you were entitled to a claim on the basis of the damage at practical completion, but the argument you've articulated wasn't advanced, or any other argument to identify how that should be quantified, or was there?
We had two things.
That should be quantified.
We had the simple sequence is this: we pleaded it, we had evidence of it because we put in for instance, a note after judgment which set out all the material facts about damage at PC.
Yes.
And we say the same scheme, the Mace scheme, applied. Because that was a scheme, we say, effectively putting right damage at period insurance on the basis that I've articulated. In other words, there's no difference. But if I'm wrong on all of that, the judge, having made a finding of what damage was, and having put together a remedial scheme which he considered was the appropriate remedial scheme, which we say had three quite distinct and separate parts taken from each party's scheme, he should have given Mace the opportunity to make submissions in that. So we would say the correct course would be to indicate his perhaps provisional view and ask Mace and the other parties what the working through of that was. Instead, what he did is denied Mace, dismissed Mace's claim, deprived them of the opportunity to participate in the subsequent quantification hearing, where Mace is the party which at least is at risk of being the paying party in all this if there is a shortfall.
So which of your grounds is that? What he did wrong was failing to give you a further opportunity to
my lord,
or make argument?
That I simply say is it's not in the grounds, it's not articulated. It seemed to me just a consequence of my submissions. For your lordship's reference, the note to the judge is supplemental A/12/203. My lord, in fairness, my overarching submission is that he, on ground 1 and ground 5, got it wrong. I'm just, in a sense, putting forward if I may say, a mid-course, which is perhaps he shouldn't have given them an opportunity, should have given Mace an opportunity to have made submissions on it.
Yes.
Now, this is my summary. I apprehend I'm not going to get far beyond my summary. So for your lordship's note, I'm going to make some brief points on ground 2. And they are brief. Yesterday, my lord, you were addressed on plenums by Mr. Rinson, and it has, in fact, 2 consequences. The first, which he explained, is they were found to be damaged, and there was substantial evidence of damage. But what actually is more significant is that plenums did not have gutters. And therefore, the only way the water could have got in, which was the pleaded way, is through the lifting strops. Had the judge considered plenums, it's at least a reasonable prospect that he would have considered there was upslope damage through the lifting strop holes because he had evidence of damage in areas where there were no gutters. Mace's scheme addressed claimants. With respect to lifting strops, we simply say this, that if the judge had considered the pleaded issue of lifting strops, he would not have chosen Insurer's scheme or the hybrid scheme, but would have chosen the Mace scheme. In relation to damaged insulation, my understanding of Insurer's response to this is that there was no evidence of separate damage to the insulation, i.e. no damage to insulation where timber or another component was not also damaged. But that is to miss the point. The insulation, the evidence was immediately damaged on the ingress of water, and the other components of the cassettes may well take time. In other words, the two are not linked. They may have the same cause, but they occur at different periods of time. And so it is no answer to the fact that the judge did not consider the insulation as an issue and make a finding on it. The damage, insulation, and at least the claimant's case on damage to the insulation is to be found in the judgment. It's not that he didn't appreciate it was an issue, it's that he failed to resolve it. Turning now to costs incurred. Mace had a claim for costs incurred of at least 10 million, and it was a self-standing and independent claim of any other claim in either set of the proceedings. See particulars of claim, paragraph 39B, reference core B at divider 21, page 537. Those costs comprised of three broad categories. Investigation costs, temporary emergency works, which was sometimes called, I think, blue supports, and Mace's remedial costs. The judge dealt with this in the judgment, paragraph 226. Which is at page 436. The context of it is paragraph 225, where the judge is dealing with remedial costs. Where you see at the end of the last sentence, he says, however, there's no proper basis on which I can conclude responsible for costs of the scheme in its entirety, either directly or on the basis it's likely to be cheaper, etc. He then goes on.
Sorry, I've lost you. Paragraph.
Last sentence of paragraph 225. It's to make the point that is where he had finished before he moves on in 226 to deal with it more generally. He says, so far as Mace is concerned, it has made no attempt to identify what sum is recoverable by it or on its behalf down to the date of practical completion, not any real-world reason why it should have sued separately for what in substance is the or a subset of the monetary remedy that Sky will recover. The incurred cost claim was not a subset, either in substance or otherwise, of the Sky claim. And he came back to that because we had misunderstood this part of the judgment. And in the first ruling, he returns to that because Mace applied for an interim payment in respect of that element. And the judge dealt with it at page 449, paragraph 32. And if I may go through this to take each of the points in turn. So the point that remains is whether there is any monetary claim made by Mace that remains to be resolved. First, I've held in the judgment that Mace had not made any attempt to identify what, if any, sum was recoverable by it on its behalf down to practical completion. Or we say that is not correct, but is not germane to this, which are investigation costs, at least in part, or why it should be sued separately from Mace for the same or a subset of the same monetary remedy as Sky. And it wasn't the same monetary remedy as Sky, and neither was it a subset. It was costs only incurred by Mace and for which there was no direction from Sky to incur them. The judge then records a submission in italics. Of course, issues were not addressed by Mace, and underlines separately, that underlining separately was underlining in Mace's written submissions, because it was saying that it had been addressed. And I've taken you to the pleading, which showed that it was materially the same case. With respect, if that is so, then it's too late now to want to advance such a claim. The point was made repeatedly by Mr. Rigney in his written oral openings and closing submissions. At no stage did Mace make any attempt to reserve its position, even if in principle it could have at that stage. And we respectfully say that's not correct. It was a self-standing claim. It wasn't a subset. It was in issue. And for the reasons I've explained, in relation at least to investigation costs, and also likely in respect to emergency works, they were all part of whichever scheme, whether at practical completion or at the end of the period of insurance. He then goes on to deal with 33 to deal with each specific point. It says Mace maintains it has a direct claim of 11.4 million odd in respect of his cost of carrying out investigations work in connection with damage to the roof. Mace is entitled to a declaration and so forth. He then goes down, about halfway down, I'll pick it up. If Mace is entitled to recover what he characterises as his direct costs, as to that, Mr. Rigney's closing submissions at the end of the trial say we haven't demonstrated any entitlement to a monetary remedy for any relevant period. Then goes on to cite Mr. Rigney's closings, and if I may just go through them because 358.1 says all of the costs were incurred in and after 2020, several years after practical completion. For reasons already set out in section C above, such costs are irrecoverable. I make one point in relation to that, which is the relevant question is, are the costs referable to the remedial works? In this case, because substantial damage wasn't identified at practical completion, there is extensive investigations to find where the damage was, the scale of it, and so forth. It is not a temporal question, it's a causation question. Are those costs referable to it? So we respectfully say the judge was wrong about that. 358.2, further, all the costs appear to concern the preparation and development of the Mace scheme in its various incarnations. However, in circumstances where the Mace scheme will not be implemented, it could not be said that the costs might be said to be incurred in the repair, reinstatement, or replacement of damaged property. Well, the investigation, we would say, was a key element in defining what a remedial scheme was. And insofar as the judge relied upon that as a ground, that was wrong. Under 358.3, finally, if this head of claim were recoverable in principle, and Mace was able to demonstrate the alleged costs had been incurred, and I haven't taken your lordship to it, but there's reference in the bundle to many witness statements dealing with what the costs were and so forth. It would still have to prove that such costs were incurred in connection with actual damage that occurred during the period of insurance, rather than in the investigation of potential or threatened damage, or of damage that post-stated the period of insurance, to which we would say the judge had already found there was actual damage to the period of insurance, and the question was, what was the remedial scheme that dealt with it? He said each of those points remained unaddressed at the end of trial, and so the second point is particularly relevant. We would say this, that those investigation costs, that element of it, which comprises investigation costs, were used for all of the parties' schemes. They were incurred for identifying what the damage was and the scope of the damage. And to the extent that there wasn't evidence that quantified that amount, if he had not treated it as a subset of the Sky claim, but as a self-standing claim, we say he would have done his best to provide a remedy in damages to claimant, to Mace.
You say to the extent there was no evidence quantifying the amount.
Well, we had
Can you give us the reference to where the costs you're talking about are set out? Someone behind you with
yes, yeah. I put it in that way. There is 1/4 point, so it's only because I'm taking it out of order, which is the judge referred to a document when dealing with this, which is annexed to this at page 469, in the same bundle, so it's annexed to his ruling. On the permission to appeal. And the judge took the view that this document showed that Mace were claiming the costs as part of its remedial scheme.
So 469
469
in the
in bundle B, core B.
this is document headed Appendix 1.
Indeed.
Yeah.
And we make one point in relation to that he was mistaken in assuming that was a document agreed by Mace. It was a document put in by Sky in its closing submissions, and it wasn't agreed by Mace. As the judge had decided there was going to be a quantum hearing, what we say is that what he ought to have done with this, if he was any doubt about the quantum of the claim, he should have done the same as he did with Sky's incurred costs, which is deal with that at the quantum hearing. So we say, and I'm going to summarise now, bearing in mind, I don't think I can go through each of the individual grounds or begin to in the time left. Insurer's response to the Mace appeal is in broad terms. It assumes, we say wrongly, there was no pleading or evidence case on damage at practical completion, and that there was no finding by the judge as to damage at practical completion. We say it assumes wrongly that the Mace remedial scheme did not seek to remedy damage as at the end of the period of insurance. And it assumes wrongly that incurred costs were a subset of Sky's claim when they were not. So, in terms of what we're inviting our lordships to do, if you are with us on all or part of the appeal, is to determine those issues of principle in the Mace appeal, but otherwise to remit the matter back to the judge to determine matters which he either hasn't determined or require further explanation. And in particular, I have in mind on that the plenums, the lifting strops, and the insulation, and to permit Mace, as a party obviously affected by this, to participate in the quantum hearing. I have the reference, my lord. It's the Quantum Joint Statement number 3, paragraphs 1.4.1 to 1.4.2, at Supplemental E, tab 65A, 951 to 952, and Appendix C, at Supplemental E, at 956.
Thank you.
You're saying that remitting some of these issues would potentially have quite a lot, have a reopen very much more substantial issues, aren't
It would, depending on his determination, yes, it would. So it would cause him to reconsider what was the appropriate remedial scheme.
It's almost asking to start again.
My lord, I don't think anybody wants the judge to start again. But on the other hand, as a party who is facing the potential for very substantial financial consequences, these issues are not small. I understand the ramifications might be substantial, for he may come to the conclusion, a range of conclusions, conceivably that it doesn't change anything, alternatively that the remedial scheme this judge has already devised is still the correct one, alternatively it needs to be either supplemented or the Mace scheme is the correct scheme, or indeed Sky would say mediation, his scheme is an appropriate one by way of mitigation. It's very difficult from Mace's perspective to get around the fact that very substantial issues with financial consequences do not appear to have been addressed. And those financial consequences have a real risk that it will be, could end up the paying party for it. And when I did, I know my Lord Popplewell was in a sense surprised at my submission when I said that the judge should have considered whether to make a provisional ruling and ask for comments. And I quite accept that criticism, or at least implicit criticism. But the difficulty is...
I wasn't so much expressing any surprise about the substance. I was asking you whether it was within your grounds of appeal.
No. And I hope candid about that. It's because, in truth, as sometimes one does, one thinks about it and asks oneself the question, what would have been the right course in such a situation? And it arises, as one can see, with particular emphasis for Mace. Because, you know, insurers take the view Mace shouldn't be present. Sky are pursuing the claim, although if they're successful but to a limited extent, they will look to Mace. Mace is the one party which has the interest, has the knowledge as the contractor, had the skills and the expertise to advance it, and it's not entitled to be present. It was for those reasons. It's certainly not for the purpose of increasing the workload of this judge. It is just unfortunate that, as sometimes these things sometimes happen. My lord, I'm 10 minutes early because I never even got into the body of my submissions. I can do, but each one of these is going to take considerable time, and so I'm quite happy to leave it there, and I may take a few more minutes in my reply, if that meets with the approval of the court.
Can't see any reason why you shouldn't have a transferable 10 minutes.
Thank you. Do you forgive me?
Yes, Mr. President.
My Lords, I was proposing to take the appeals in turn, which is to say I'll start with the Sky appeal, then move on to Mace, and then conclude with our own appeal, if that's convenient for the court. And my Lord, I wonder whether perhaps before turning to the Sky appeal, I could just make one or two observations by way of a general introduction, just about the shape and genesis of the proceedings and the way in which the claims of the schemes have been brought. And the reason for doing that is because it affects various of the issues which we'll have to come to consider in due course. Now, my Lord, of course, this is a dispute which concerns the policy and the indemnity which it provides. But lying behind it is another dispute, and that is the dispute between Sky and Mace under the building contract. And my Lord, that dispute has informed the character of these proceedings and what it is that Sky and Mace are claiming for, or were claiming
particular, my Lord, what is important to understand is that from the outset, insurers pleaded that the claimants were only entitled to an indemnity in respect of damage which had occurred as at the end of the period of insurance. And then by amendments granted by the judge in August 2022, insurers pleaded two schemes which were intended to identify the work by way of assessment, to identify the assessment of the work which would be required in order to treat damage, first of all, as at the end of the period of insurance, and then secondly, as you've heard about, the damage as at the end of the drying out works in 2018, 2019. And, my Lord, it's worth observing that, of course, insurers were under no obligation to put forward any scheme. The measure of the indemnity was a matter for the claimants to prove. It's only because insurers put forward those proxy schemes that there was evidence that as to what the cost of remediation might be, as at 2017 and as at 2018-19. Now, my Lords, by way of contrast, Sky advanced a scheme which is provided for an entirely new roof, designed and constructed to a superior design, by which the wooden cassettes were to be replaced with new metal cassettes. And that was without regard to any incidence of damage. And the reason why Sky did that is because that is something to which Sky would be entitled under the building contract in order to have a roof which was fit for purpose from the outset, according to a proper design which met the specifications of the building contract. But, my Lords, that's not something to which Sky is entitled under the policy. Sky and or Mace, if insured for the relevant period, are only entitled in respect of the rectification or the repair of damage, and indeed that's all that they claim for. Now, my Lords, the scheme that was put forward by Mace in its original particulars of claim addressed what was said to be damage primarily in the gutters, and that was costed at £86 million. Now, what then happened was that I think in the early part of 2022, Sky became dissatisfied with the Mace scheme. And as a result of that, Mace put forward a new and much more extensive scheme. And that was costed at £196 million. It was put forward in November 2022, so a few weeks before the commencement of the trial. And the distinctive feature about the scheme, and my Lords, this is something we'll come back to when we look at this issue of investigation costs under ground 4 of the Sky appeal. But the distinctive feature about the scheme is that it presupposes that every single cassette needs to be repaired in the same amount and will take the same time, that is 9 days. That is the premise of the Mace scheme. And one of the submissions that I've been making when we come on to investigation costs is that that isn't contingent upon the outcome of those investigations. That scheme has already been devised, and that was the scheme for which Mace and indeed Sky claimed indemnity under the policy before the judge. But as I say, I'll address that, if I may, in a little bit more length when we come on to consider the investigation costs aspect of the appeal. Now, the reason why Mace put forward that scheme was in order to discharge its obligations under the building contract and also to satisfy Sky's expectations under the building contract. Both schemes were designed to obviate all the damage, not which had occurred as at the end of the period of insurance, but all the damage up to the date of trial, and indeed which might continue to occur whilst an appropriate remedial scheme was being designed and being implemented. And although I think, for the purposes of this appeal, Sky contend that it's entitled to claim in respect of damage up to 2023, the case that was advanced before the judge was that any deterioration up to 2029, which was the date upon which it was contemplated that the proposed scheme would be completed, all that would be the subject of the indemnity as well. In other words, neither of these schemes was designed to address damage as at the date of the period of insurance, because both of them were concerned with the obligations of Sky and Mace inter se under the building contract, not the indemnity which is provided by this policy. And it was this approach of Sky and Mace which caused the evidential difficulties to which the judge referred in his judgment. And I can just give you the reference, I think, without going to it. It's in his main judgment at paragraph 182. And my lords, when we come on to look at the factual aspects of Sky's appeal, one of the things I would like to do is to go through the structure of the judgment and see how it was that the judge came to the conclusions that he did, and in what circumstances, and as a consequence of what evidential difficulties. Now, my lord, with that very brief introduction, I wonder whether perhaps I might start with the Sky appeal, and in particular with grounds 1 to 3, which broadly concern the period of insurance. Now, my lords, as you know, Sky contends that it's entitled to be indemnified not only in respect of damage which occurred within the period of insurance, but in addition to two other things. First of all, what it characterises as inevitable further damage which occurred after the end of the period of insurance, whilst the remedial schemes were being designed and then, no doubt, subsequently implemented. And then secondly, damage which occurred within the period of insurance, which it says then developed thereafter. Now, my lords, you've very helpfully been taken to the insuring clause in the policy already. I don't think I need to invite your attention to it. I can just remind you precisely what it says. And it's this, that the insurer shall indemnify the insured against physical loss or damage to property insured occurring during the period of insurance from any cause whatsoever. Now, before turning to those words, can I just make a brief point about the character of the policy? This is not an annual policy. This is a specific project insurance. The period of insurance is extended to 1 year beyond the date of practical completion, and it's intended to cover, and in fact covers, damage until the end of the maintenance period. But damage until the end of the maintenance period and nothing further. And my lord, no doubt when we come to discuss fire and subsequent year examples, my lord, that is something which one needs to bear in mind. This is not an annual policy. Now, my lord, before turning to the more substantive submissions, can I just make a couple of points?
But you're not suggesting that the wording is materially different from the sort of wording you would find in an annual policy, a property policy?
My lord, the point's not so much about the wording. It's simply about the context of the policy and what it is that it's designed to
I understand the
achieve.
context of this particular policy,
Yes.
but some of the points about how to construe wording of this type or property policies more generally
Yes.
would include policies which had similar wording.
But my lord, they would.
You're not suggesting this wording is completely bespoke and not to be found in...
No, in fact, I'll be taking some cases where the word is very similar. I want to make some points about those. But it is just simply to bear in mind in terms of what it is that this policy is designed to do and what its purpose is.
Is it the sort of wording one finds typically in household insurance?
You can find similar wording in household insurance. And my lord, so as far as preliminary points are concerned, we submit that what Sky characterises as deterioration or development is in fact describing damage which occurs outside the period of insurance and was not present within the period of insurance. It is, in other words, new or additional damage. And in our submission, even if such damage were inevitable after the period of insurance, it would make no difference to the question of coverage. And my lords, there's been a certain amount of discussion of mitigation over the course of the last day and a half. And my lord, perhaps I should make our position on that clear. The reason why insurers didn't advance a case as to mitigation is because in our submission, questions as to mitigation simply don't matter and don't go into it. And can I perhaps just give you an example to try to illustrate what we say the point or the position is? But assume for a moment that it would be perfectly reasonable for a responsible building owner in the position of Sky to spend 3 years in devising an appropriate remedial scheme. Assume also that during that 3-year period, the damage affecting the building spreads or increases. It may well be that the prudent, responsible building owner would ensure that the scope of the eventual remedial scheme addressed such additional damage. But insurers are not liable to indemnify such a building owner in respect of such additional damage, because insurers' promise was only to hold harmless in respect of damage occurring within the period of insurance.
Well, that's just stating your case.
That's stating the case. That's our case, my Lord, yes, to make quite clear what the submission is. And my Lord, we say that mitigation simply doesn't come into it. Rather, what one does in relation to the insured damage is carry out an assessment. And that was the purpose of the two schemes that were advanced by insurers. You know our primary contention is that the appropriate one is 2017. That was its purpose. It was an assessment of damage. You don't look at what then might have happened factually once that damage had occurred in order to create and generate a scheme. All you're concerned with, that's the assessment.
You put forward two schemes based upon your interpretation of the contract, and the judge accepted that
Precisely.
that was the correct interpretation. Yeah. So he said those were the
Precisely.
two choices he had to make. If he'd have been against you on the construction of the policy, your two schemes would have fallen away.
Of course.
And he would have been looking at
something very different.
Something very different.
Quite. But absolutely. But I just wanted to make sure that our submissions are set out. And can I just, again, just by way of preliminary point, address the question of access, which I think was raised yesterday. And it was suggested, well, access damage would be covered if the purpose of the access was to assess, but rather to repair the damage that had occurred during the period of insurance. And my Lord, I think we agree with that. The reason why that is recoverable...
Assess, or, sorry...
Forgive me. Access damage caused in order to repair the damage that had occurred during the period of insurance.
What about access damage caused to assess? Because that was your first, perhaps Freudian or not, approach to it. What's the answer to that question?
The answer to that question, we submit, is that this policy does not provide cover, in general terms, for investigation costs. There's certainly no cover for investigations that disclose no damage. Well, it's perhaps a more complicated position if, in fact, damage is discovered. And I wonder whether perhaps I can come on to that question in the specific context of ground 4, which relates to those investigation costs, because to some extent we may need to get into questions of reasonableness. We will certainly, I think, need to have a look at Jan de Nul, and those questions are, I think, perhaps more easily dealt with in that context, if that's convenient. I don't want to not answer the question. Well, just looking at access damage, then, and the example that was given yesterday, the reason why that is recoverable, if its purpose is to repair the damage that's occurred during the period of insurance, is that it is part of the repair of the insured damage. It's a very different thing, different in kind, different in purpose, from deterioration or additional damage that occurs after the end of the period of insurance.
So you say, if you know where the damage is, the cost of accessing the damage to repair it is recoverable, even though it's access damage inflicted on the building or inflicted after the period of insurance. But if you don't know where the damage actually is and you're just looking for it, then no, not covered.
Yes.
What's the logic behind that?
Because the policy only covers...
Yeah, what's the logic? What's the commercial logic behind that?
The policy is just simply there for loss and damage. Now, if in fact...
Yeah, but I can read the words as well as anybody. I'm asking you for the commercial logic behind the distinction that the policy is set on your interpretation to draw.
No, the commercial logic is that investigation, pure and simple, it is something which doesn't count as physical damage. And that, as I say, if in fact the investigation...
With respect, I think I can read the words as well as the next person, I hope. What's the commercial rationale for the policy drawing the linguistic distinction that you are highlighting? Why should it be commercially sensible for insurers to pay for the access costs to remedy, but not the access cost to find what's needed to be remedied?
Well, look, that then may get into the question of whether there's a distinction to be drawn between investigation costs which relate to damage which is in fact found, and investigation costs where there's no damage at all. But we would submit that plainly, if there is no damage, then that is a situation for which there can be no recovery, whether you've carried out an investigation or not. Now, if one then gets into the situation where damage is found, then that may turn on questions of reasonableness, and it may turn on the specific circumstances of the case. And that, I think, my Lord, is where one then has to address cases such as Jean de Nul and what it was that that policy provided for. Because, of course, that policy provided for the financial consequences of damage. Our policy provides only for the repair, rectification, replacement of damage.
Why isn't the cost of accessing undamaged cassettes part of the cost of repairing damaged cassettes? Because you cannot repair the damaged ones unless you have looked in undamaged ones.
Well, that goes to the discovering the extent of the damage, I think, is the point that's being made. Well, our submission is that our primary submission.
Well, let's say you've got 100 damaged cassettes. The cost of repairing those 100 cassettes includes looking at the undamaged ones. That's part of the process.
Well, that's looking at property that's not damaged, we would say.
Well, that's got a narrow view of it, isn't it? Because you know that you've got damaged cassettes. You cannot repair the damaged ones unless you look for it, and therefore the cost of repairing the damaged ones includes the costs of opening up the undamaged ones. I mean, it's a causation aspect. You simply can't do the repair, the damaged ones, unless you've opened up the undamaged ones. So it's part and parcel of the overall cost.
Well, look, perhaps I wonder whether one way of putting it is this, to say, well, if there is insured damage, then that may lead to a question of whether the investigation costs can be said to be part of the full cost of repair. And if that's right, then that answer is likely to be informed by the question of whether those investigations are reasonable. And in the context of ground 4, and as I say, I think this does need to be seen in the context of ground 4, but I ought to address the point that you've raised now. In the context of ground 4, what we will be saying is that the expensive opening up scheme, which is contended for by Mace, for a whole series of reasons that I will come to, is not reasonable, not least because actually nothing turns on those investigations and the costs that are associated. During the course of the trial, I don't think the investigation costs were identified as a separate item. But as I've indicated, the repair scheme for which Mace and Sky contended was the scheme, irrespective of what those investigation costs would discover.
But you say even a reasonable investigation scheme would not have been covered unless it actually turns into a reasonable, successful investigation, and actually,
yes,
or only to the extent it becomes a reasonable, successful investigation, actually finding,
yes, actually
not even finding, just, well, perhaps finding,
yes,
in the damaged goods damaged parts in order to repair them.
Yes.
As an example, imagine you had a cargo of grain, very large cargo, and it's realised that it's part of it, some of it, is infected with weevil. And that's going to be a progressive damage. The weevil is gradually going to eat its way through the grain if you don't fumigate it. Now, most of the grain presently isn't damaged. It's absolutely fine. But you've got to fumigate it all, even though that means you're fumigating large parts of it which is completely undamaged, because there is known to be some damage to at least part of it. You couldn't say, could you, that you could only have the cost of fumigating part of the cargo. You've got to fumigate it all to fumigate that part which is infected.
Well, it may be that the question is fact specific. It's going to depend on the example that's given, perhaps.
No, but you'd say contractually, hence my previous question, which I think prompted that example. You'd say doesn't matter. doesn't matter. You only get that part of the cost of fumigating the damaged bit that's got weevil infestation, because that's what the contract says. And my question to you prior to that was, what on earth is the commercial purpose of people entering into such a contract? Because I think you are supposed to assume that the people who enter into this contract are commercial people.
Well, I wonder whether then perhaps shamelessly I can duck that and come back to it into investigation costs. I'm just conscious of the time on the authorities I want to take you to, but look, I understand the question, and I can see.
I viciously seized on your misspeaking when you talked about access costs, so sorry about that.
No, look, absolutely not. And look, it's very helpful because I now know what I'm going to have to deal with in relation to investigation costs, and I'll do my best to do that. But I wonder if I actually can just have a quick look at the period of insurance, and then come back to that. Now, but look, in relation to the period of insurance, what the judge held is at paragraphs 68 to 78 of his judgment. And I don't need to take you to that in detail. Can I just summarise what he found? First of all, he found that the damage is the insured event, which has to occur within the period of insurance. Second, he found that cover provided by the insuring clause is confined to damage occurring during, but not after, the period of insurance. And then third, he found that the effect of cases such as knife and faith is that provided that the insured event occurs within the period of insurance, the insured can recover for its consequences, financial losses, even if these can't be fully ascertained or quantified until after the expiry of the period of insurance. Now, my Lord, just by way of a preliminary point, you know that in Collinville, the editors make the point, and I'll just give you the reference, it's the Authorities Bundle, tab 80A, page 2124. They make the point that subject to the wording of the policy, coverage may be triggered by the occurrence of damage or the occurrence of an insured peril. Now, in the former type of policy, they make the point that it's necessary to look at the date of damage. Now, my lords, our policy is plainly a policy which requires the occurrence of damage during the period of insurance. It's therefore the former type policy. And for that reason, my lords, we submit that the judge was right to focus upon the occurrence of damage as the critical feature of the policy, as he did at paragraph 30 of his main judgment. And it follows from all of that, my lord, that to attract cover, such damage has to occur during the period of insurance. Now, my first submission is a very straightforward one, and it's this. Damage which occurs after the period of insurance does not, by definition, occur during the period of insurance. And that's not dependent upon an examination of other clauses in different policies. It's simply a matter of reading the plain English words, and nothing more, we submit, is required. So, for example, if two people arrange to meet during the Christmas holidays, that is not an arrangement to meet in February. And we say that that analysis applies, whether the case as to what happens after the period of insurance is expressed to be deterioration or development. Now, my lords, if authority is required for such an approach to a clause with a limitation, then in our submission, such authority is to be found in the FCA test case. In that case, the relevant limitation in the insuring clause was a spatial or geographical one, whereas the limitation in our clause is a temporal one. Now, I'll take you to the relevant paragraph in a moment, but can I just set the scene by indicating that the insuring clause provided cover for business interruption caused by any occurrence of a notifiable disease within a radius of 25 miles. Now, with that, I'd be very grateful if you'd be kind enough, please, just to go to bundle 65 of the authorities bundle. And if you'd be kind enough, please, then turn to page 1693. My lords, ordinarily I would introduce the facts in a little bit more detail, but it's just this, it's an approach to construction that I want to invite your attention to. For that purpose, I don't think we need to look in any great detail at the facts. They emerge sufficiently from paragraph 61 at page 1693. Now, what Lords Hamlin and Leggett say in relation to the decision of the Division of Court is this: that the court below did not spell out in its judgment precisely how, as a matter of the English language, it considered that the words any occurrence of a notifiable disease within a radius of 25 miles of the premises can be read as meaning a notifiable disease of which there is any occurrence within a radius of 25 miles of the premises. Our emphasis. It's not been suggested that this is one of those rare situations in which the court can be satisfied that in Lord Hoffman's phrase, something must have gone wrong with the language, and can engage in verbal rearrangement. Another reference to well-known cases. That if there were no obvious meaning of the words used and they were reasonably capable of bearing more than one possible meaning, the considerations mentioned at paragraphs 56, 57 above, which influence the court below, would have been relevant in determining which meaning is to be preferred. And then the critical paragraph, section is this: but we do not consider that there is any ambiguity in the description of the relevant insured peril. No reasonable reader of the policy would understand the words any occurrence of a notifiable disease within a radius of 25 miles to include any occurrence of a notifiable disease outside a radius of 25 miles. To seek to interpret the language of the policy as bearing such a meaning is to stand the clause on its head. But Lord, we submit that is precisely what the contention of Sky does to this clause. It stands it on its head because it treats as falling within the cover of a clause which provides cover during a period of insurance. It says that damage which occurs outside that period is somehow brought within it. Now, my Lord, can I now give you two instances, and I said I would do this, of first instance judges looking at clauses which are similar, very similar to our...
But how far does that go? There are some investigation costs, you say, which are recoverable. They're incurred outside the period of insurance. Why doesn't your argument apply to them?
Well, it's the damage, the Lord, that has to occur within the period of insurance. I wasn't so much addressing costs as damage.
Well, what are the investigation costs if they're not damage then? Are they reasonable costs of mitigation?
Well, my Lord,
which you say doesn't apply?
But that's investigation cost point. What I was hoping to address was simply the question of which is relevant damage for the purposes of the policy and that falls within the insuring clause.
Right.
Now, what
you'll come back to whether investigation costs are damage.
I will come back. I promise I'll come back.
I'll put it on your list. Thank you.
Of course. But what I wanted to establish is this, that in terms of the parameters of the discussion that took place yesterday, and whether or not developing, continuing, deteriorating damage can be said to fall within the ambit of cover, we said that as a matter of construction, you can derive assistance from the approach that the Supreme Court took in the FCA case, because it made what one might have thought was the straightforward point that something that means within doesn't mean outside, and we would say something that means during doesn't mean after. The point is as straightforward as that, but it's a matter of ordinary English construction. Now, look, what I was hoping to do was just to take you very quickly to a couple of first instance decisions where the judges in question had approached clauses such as this in such a way we would submit. Now, if I could begin, please, by inviting your attention to the case of Martini and McGlynn, which is a decision of Mr. Justice Timothy Walker. My Lords, you'll find that, please, at tab 25 of the authorities bundle, and it's at page 509, where you'll find it. Now, my Lord, this was a case in relation to damage to a family home in Montserrat.
I'm there now.
It was damage to a family home in Montserrat from volcanic explosions which deposited tephra in the property. And the property was damaged in part by deposit, but mainly by corrosion. Now, the insuring clause in that case was, as set out in the head note in column 1, just in the second paragraph, the underwriters hereby agree to the extent and in the manner hereafter provided to indemnify the assured against loss or damage sustained or legal liability for accidents happening during the period stated in the schedule. So that was the insuring provision. And the buildings cover, we'll see just beneath it, insured buildings against loss or damage directly caused by, amongst other things, explosion. So that was the peril. Now, the issue in the case was whether damage was approximately caused by the explosion, and then how much. And I wonder whether perhaps I could just invite your attention, please, to page 510, the first column and the final paragraph. It reads as follows. It seems to me that as a matter of simple grammatical construction, the word for in that clause only links liability and accidents happening and can't also link damage sustained and accidents happening. Therefore, the damage cover under the policy only relates to damage sustained during the period of the insurance. To find out the extent of the indemnity, it is then necessary to look at the buildings cover in section 1, which is the first peril insured against, covers the buildings against loss or damage directly caused by explosion. Given the focus of the insuring clause on the loss of damage, the learned judge makes this point, that it's fortunate indeed for the owner that an inspection of the property was carried out by a local engineer almost exactly contemporaneously with the end of the cover, and a detailed financial assessment made of the existing damage then found. Now, my lord, the reason why I refer you to this case is that, of course, one of the points made by the judge in our case was that it would have been extremely helpful had there been some sort of survey, as at the end of the period of insurance, in order to assess the damage. That's one of the points that he makes.
Maybe, but in the real world,
Well,
where often you may have damage which doesn't exhibit itself until much later. That's a pious hope, isn't it?
Well, except in this case, fortuitously, there was such a survey. And the reason I invite the court's attention to it, the reason why it's relevant is why it is that it's fortunate.
Well, I understand. You say that the judge is saying it's fortunate because he must think otherwise one wouldn't be able to identify the extent of damage. But it perhaps emphasises how unrealistic commercially the insurer's case is if the only safe way of identifying the measure of indemnity under a policy of this kind is to have a survey at the very moment of the expiry of cover, which in the real world will almost never happen.
But my lord, it may well never happen in the real world. But my lord, in my submission, I'm not sure it's right to say that that's the only safe way. And indeed, the judge found that the way in which Mr. Coulson went about the assessment of what the damage was, namely the extrapolation back from photographs in 2018-19, was the best approach that could be taken in order to arrive at the correct assessment.
That then rather undermines your reliance on this case because it isn't fortunate at all. There are other ways of doing it.
Well, but the point wasn't so much about how you go about it. It's why it was fortunate. It was fortunate because what you had to assess was damage at the end of the period of insurance. That's the point I get from it. It's not whether you need to have somebody there at the time. It's what it is that they would do if they were there at the time, and what they would assess would be the extent of damage as at the end of the period of insurance. That, in our submission, is what one gets from the case.
The argument wasn't about the sort of argument we're having now, was it? I mean, the argument about was whether the corrosion was proximately caused by the deposit of the tephra. And the answer was yes, it was.
Well, look, that was certainly the issue in the case. The reason why I invite your attention to this is because the learned judge thought that the way in which a policy or a clause such as this should be approached was a straightforward matter of assessing what the position was at the end of the period of insurance. And what's noticeable is that in that case, as a matter of fortune, there was a surveyor there who was able to provide extremely good evidence of what that was. But the purpose is just merely to point out that in a clause such as this, and Lord Justice Popplewell asked whether perhaps other policies might have similar clauses. Well, here's a similar clause, and the learned judge found no difficulty at all in finding that what had to be assessed was damage as at the end of the period of insurance.
Well, he didn't find that, but what he said, what he said implies that that's what he thought. That's what you're saying.
Quite right. That was loose language from my part, and I do apologise.
But he wasn't being asked to award damages for continuing corrosion, was he?
Yeah, there was no
fortuitously. There was a report at the end.
It's an aside on a point that wasn't argued, but you're entitled to say he obviously thought that was the position in order to make that comment. Is that fair?
I'm content with that. That's the point. Now, perhaps then, the other case I was going to invite your attention to, I'll simply give you the reference for it because you may think that it falls into the same category. It's the Otokumpu case. That's at tab 41. It's a decision of Mr. Justice Tomlinson. And the relevant paragraph that I would have invited your attention to, but perhaps in the interest of time, I would leave simply for your note, is paragraph 30. in terms of how he approaches clause C. Now, my Lords, those are broadly introductory points. I wonder then whether I can just come on to the main submission that insurers make in relation to the construction of the insuring clause in this case. And I'd like to do that, please, then by reference to a number of the authorities, some of which were referred to yesterday. And the submission is that it is a fundamental principle of English law that in a property policy providing cover for damage within or during the period of insurance, cover is only provided for damage which occurs during the period of insurance. And my Lord, that we say is a fundamental principle. Now, what I would like to do, if I may, is first of all address the fundamental principle and then come back and look at the question of alleged developing damage in the context of Knight and Face, Anderson and Martin, the Renos, and so forth. Because in our submission, it's quite important that first of all we establish what the principle is. Only having done that, can you then see what the context is in which those cases arose and what effect, if any, they have on the principle in question. So if I was going to start with MMI, but I'm just looking at the time, it's 2 minutes to 1. It's going to take me slightly longer than 2 minutes to go through it, I think.
That sounds like a convenient moment.
I'm very grateful.
Right, totally.
All rise at table.